Welcome to Legally Sevvy, where today we will talk about the motion to dismiss filed by Leslie Sloane and her PR firm in the Blake Lively case.
Weeks after Justin filed a defamation complaint against his It Ends With Us co-star Blake and her husband Ryan in response to her sexual harassment and retaliation lawsuit against him and named their publicist Leslie Sloane as a co-defendant, the Vision PR owner filed a motion on February 20th to dismiss his countersuit.
On February 20th of 2025, Sloane, through her attorneys, filed a motion to dismiss based on the pleadings. They argue that the complaint itself does not present any facts or arguments that will lead to Blake Lively winning her case in court. In the memo of law, Sloane states that she and her PR firm, Vision PR, was dragged into instant litigation as basically a smoke and mirrors exercise to distract from their own sexual harassment and systemic retaliation. They point out that the New York Times article cannot be connected to Sloane or her company, and there was nothing in it that was a malicious story or invented as part of a smear campaign. Sloane further explains that Blake Lively's complaint consists of text messages where, as you can see, she didn't even write or send. Sloane seeks the court to dismiss the lawsuit against her and her company on three main grounds that we'll discuss. First, Lively does not differentiate between her and Baldoni and any other defendants. The complaint uses the word defendants, plural, in many situations and does not indicate what defamatory statements Sloane and her company made specifically. They further state that they should not be held liable for an alleged defamatory statement made by the New York Times article that they didn't even write. 2. Sloane points out also that civil extortion is not a recognizable claim under New York law. What we have here is an argument that is often referred to as forum shopping. Generally, you might look at different states, because all laws are different, and find that some states might be better for you in a lawsuit. Some states might be worse. All the laws are interpreted very differently, even if they sound very similar. However, to prevent litigants from forum shopping, you have to clearly look at where folks reside, their ties to the state, and where the conduct occurred. Lively asserts that California law applies to Sloane and her company, but it doesn't prove why it should. Lively lived in New York at the time, and all the relevant conduct occurred in New York, and Lively alleges the harm she suffered happened in New York. And consequently, Sloane argues that because of that, New York law should apply and not California law. If New York law applies, then civil extortion is not a claim that you can make under New York law. And even if it applied in California, the attorneys even say the courts have not ruled whether or not civil extortion is a cognizable crime under California. Third, Sloane argues that Lively failed to state a claim for defamation. The statements that were attributed to Sloane in the complaint were: 1. The whole cast doesn't like Justin. 2. The whole cast hates him. And Blake was sexually assaulted. Sloane argues that these three statements cited in the complaint cannot give a rise to defamation. Again, for defamation, we need a factual statement that is false, not an opinion. If you make a factual statement and it is true, that is a defense under defamation. Or if you give an opinion, that is also something that you can raise as a defense for defamation. Because for defamation, you need a factual statement that is false. Also, you need a statement that is made with actual malice and a statement that would give rise to special damages. In any event, Sloane argues that all of those statements, all those three statements that we just mentioned here, cannot even be attributed to her. Because again, when we read the complaint from Blake Lively, we saw those text messages. And Sloane was not writing those text messages. It was somebody else talking about it. somebody else's interpretation of what Sloane said. So now the Lively team will have to respond to the motion to dismiss by opposing it, and the court will set a date to make a ruling on that decision. So again, Sloane has three main arguments for her motion to dismiss. One, she said that Lively does not differentiate between all defendants enough and you need to be very particular about it. Second, Sloane pointed out that civil extortion is not a recognizable claim under New York law, and Blake Lively was forum shopping, which she shouldn't have, according to them. And then thirdly, they say that she fails to make a case for defamation. What do you think? Let me know what you think should happen. Should this part of the lawsuit be dismissed? Please make sure to write it in the comments. Please also remember to like the stream and subscribe. And I will talk to all of you later. Bye, everybody.